Many thanks for your company. We are coming to you live from digital address GA0993 2539. I beg your pardon. I'm Bernice Abubedu. In our first story, there's been a new challenge to the controversial Ghana-US defense agreement ratified by Parliament last week. A second case in 24 hours was filed at the Supreme Court late afternoon yesterday, and that's seeking to overturn the ratification of the deal. The case, filed by private citizen Emmanuel Kutin, has the Attorney General as defendant, and the Ashanti regional organizer of the NDC, Emmanuel Broja Jamfi, also filed a similar case earlier yesterday. So what exactly is Mr. Kutin, Emmanuel Kutin, seeking in that particular suit? Let me run you through some of the reliefs. Now, he wants a declaration that on a true and proper interpretation of Article 75(2)(b) of the 1992 Constitution, there must be an agreement executed by the government of Ghana and the United States of America before the same can be ratified by the Parliament of the Republic of Ghana. Another is a declaration that to the extent that the purported defense cooperation, the status of United States forces and access to and use of agreed facilities and areas in the Republic of Ghana was not executed between the government of Ghana and the United States of America, upon which a liability will lie as at the 23rd of March 2018, and as was laid before the Parliament of Ghana, and there was nothing before Parliament to be ratified. Now, another is a declaration that to the extent that a defense cooperation, the status of United States forces and access to and use of agreed facilities and areas in the Republic of Ghana was not executed between the government of the Republic of Ghana and the United States of America as at the 23rd day of March 2018, before same was laid before Parliament, and the United States and, I beg your pardon, and the United States of America as of the 23rd day of March 2018, before same was laid before Parliament, any purported committee proceedings in Parliament approving and recommending same for subsequent ratification by the plenary of the Parliament of Ghana, and any subsequent resolution passed by the Parliament of the Republic of Ghana is in contravention of Article 75(2)(b) of the 1992 Constitution, and the same is null and void. And as a collateral issue, whether or not any decision by the government of Ghana to execute any purported defense cooperation, the status of United States forces and access to and use of agreed facilities and areas in the Republic of Ghana is in a manner consistent with the national interest as espoused in Article 73 of the 1992 Constitution. So those are the reliefs being sought by Emmanuel Kutin, a private citizen seeking to overturn the decision by Parliament to ratify that agreement with the United States government. Meanwhile, the minority in Parliament has served notice it will oppose a 2015 defense cooperation agreement signed by their own government with the U.S. That is, if the contents in there are not what they want. Now, the current administration yesterday confirmed to Joy News they will send the agreement to Parliament for ratification. Information Minister Mustafa Hamid has disclosed MPs are likely to be recalled for an emergency sit-in to ratify the deal, which was signed by former Foreign Affairs Minister Hannah Tete.
We believe that they know that this agreement is nothing dangerous to the welfare and safety or security of the Ghanaian people. But of course, I can understand that sometimes in opposition politics, you ought to do things to score political points. So with the 2015 one, we are hoping and praying ardently, quite frankly, that because they themselves signed it, it will be much easier for them to cooperate with us to give it ratification so that we don't jeopardize the current arrangements that are going on between us and the U.S.
While Minority Chief Whip Muntaka Mubarak says they will not change their stance. Well, he, however, criticizes how former Foreign Affairs Minister Hannah Tete handled that 2015 agreement.
Look, when Hannah Tete was going to sign it, who did she involve? She didn't involve Parliament. So why are you saying you? Call the individual that signed it. The person did not sign it with my mandate. I have the mandate of people of Aswansi. They don't have my mandate, regardless of whichever government it is. those articles that are inimical to our country, we shall oppose it, regardless of who is bringing it. If you bring this one in the same cast, believe it, we are going to oppose it.
So what exactly is this back and forth with the Ghana-US defense deal? Because we're made to understand the 2018 agreement was supposed to actually supersede the previous agreement. So why the plan to ratify the 2015 agreement? We'll get some analysis on that shortly. But then what is common to the three agreements and what exactly is different? Let's take a look at this information put in graphics for us. So in the 1998 agreement, it was provided that U.S. military personnel and civilian employees of the U.S. Department of Defense who may be temporarily present in Ghana in connection with the African crisis response initiatives and other activities should be accorded the status equivalent to that accorded to administrative and technical staff of the United States Embassy under the Vienna Convention on Diplomatic Relations of 18 April 1961, and that they may enter and exit Ghana with United States identifications and with collective movement or individual travel orders. So these are the similarities between the 1998 and 2018 agreement, just running you through them. Again, the 1998 agreement also required that personnel be authorized to wear uniforms while performing official duties and to carry arms while on duty if authorized to do so by their orders. And in the 2018 agreement, it provides that military personnel may possess and carry arms in Ghana while on duty if authorized to do so by their orders, such authorization being made in consultation with the appropriate authorities of Ghana. Military personnel may wear their uniforms while performing official duties. So there you have it with regards to this particular detail. The 1998 agreement also requested the government of Ghana accord duty-free importation and exportation, as well as exemption from internal taxation on products, property, material, internal taxation on products, property, material, and equipment imported into or acquired in Ghana by the United States government in connection with their official activities. Well, also with regards to vehicles, vessels, aircraft owned or operated by or exclusively for the United States Armed Forces shall not be subject to the payment of landing or port fees, piloted charges, navigation or overlight charges or light and harbor dues while in Ghana. However, the United States Armed Forces shall pay reasonable charges for services requested and received. Such aircraft shall observe local air traffic control regulations while in Ghana. So those are the similarities there. Let's check out what the differences are in the Ghana-US agreement. So the first one was the similarities between the 1998 and 2018 agreement. Now the differences in all three agreements. The current agreement requires more stringent commitments from Ghana. Clause 2 of Article 2 of the agreement clearly grants the U.S. Army rights of refueling of aircraft, landing and recovery of aircraft, accommodation of personnel, communication, staging and deploying of forces and material. This is not in the 1998 agreement. The current agreement also says Ghana hereby provides unimpeded access to and use of agreed facilities and areas to United States forces, United States contractors and others as mutually agreed. Such agreed facilities and area or portions thereof provided by Ghana shall be designated as either for exclusive use by the United States forces or to be jointly used by United States forces and Ghana. And also Ghana shall also provide access to and use of a runway that meets the requirements of United States forces. Again, no such expansive provision can be seen in the earlier agreement signed 20 years ago. Neither is it in the 2015 agreement. Let's now get onto the phone lines and speak to lawyer Martin Kpebu for more on this. Good morning, sir. Thank you for joining us.
Good morning.
Yes. So what exactly does the Constitution say in an instance where one intends to overturn a ratification?
Please say it again. One intends to overturn.
Yes, a ratification. So, for example, we know that the 2018 Ghana-US military cooperation agreement has been ratified by Parliament. Yesterday, two citizens filed a suit at the Supreme Court seeking to overturn the ratification of the deal.
Yeah, what the Constitution says is that you see, if anybody does anything that a citizen thinks is unconstitutional, then the citizen may come to the Supreme Court. You see, so that's it makes it clear that if anybody does anything, okay, that you as a citizen, in your estimation, you think it's unconstitutional, then you have a right to go to the Supreme Court for that declaration, a declaration to the effect that the conduct of that person is unconstitutional. So, but it's up to the person invoking the jurisdiction of the court to prove. You see, so to make it clear that when a person alleges that an enactment or anything contained in or done or be any act or omission of any person is inconsistent with or in contravention of a provision of the Constitution, that person may bring an action in the Supreme Court for a declaration to that effect. So that's Article 2. So as for cases with Supreme Court against parliamentary conduct, there are many. There are many. In our history, there are so many cases on this. So, but quite a number have failed, and some too have been successful. So it all depends on the fact of each case.
All right.
If the Supreme Court finds that it's a case, the Supreme Court can annul the ratification. If the Supreme Court finds there's no case, then the case will be thrown out.
But are you able to give us some insights into the merits of these two cases?
Oh, then I'll be caught fairly by this.
Exactly. But Mr. Kpebu, right now, the case also is that the 2015 agreement, we hear that Parliament has to ratify that agreement. In the eyes of the law, this particular one that has been ratified, the 2018 one, is it legitimate if we start executing it before the 2015 agreement is ratified?
The 2015 one, so what we would say is that it would appear that it's a public reaction and everything that has drawn the government's attention then to the fact that then let's go for to ratify the 2015 one. Because you would see that so far, from what we read in the news, people were not aware of it. Even within the previous administration itself, I'm sure your station has interviewed so many people who didn't even know that it existed. So I guess it's on that basis that this current administration is seeking to now take it to Parliament for ratification. I thought, I haven't seen the 2015 one. So far from what we're reading, I thought they said it had been incorporated into the 2018 one. If that is so, then it's difficult to see why you would take the 2015 one back to Parliament. But as I said, I haven't seen it. It's based upon what is said on radio. Because so far from what is said on radio and TV, we kept hearing that this 2018 one, which was just ratified, is a consolidation of the 98 and then the 2015 one. You see? So, but, I mean, when you're handicapped because it's not in the original document, this is it. So I have to say that, well, let the government take the step, then we'll see how Parliament will deal with it.
So what's the way forward now? Because we heard from Defense Minister Dominic Nitiwol a few days ago that there was going to be a joint committee set up from the Ghanaian side and the US side to execute the agreement. Now that these two citizens have filed their case at the Supreme Court, is there any way that could affect executing this agreement?
No. On the face, so far, no. Because you see, these citizens who have gone to court have not sought for an injunction. You say, yes, if they want to actually stop the execution, then the citizens would have to apply expressly for an injunction to restrain Parliament. But I tell you, that is a very tall order. You say, yes, a very tall order. So that usually these are not matters that the court will likely grant an injunction. You see, because when there is a huge public interest at stake, perhaps if those who went to court, perhaps if there were many in their thousands, then it would equally have signaled to the court that this is a very, the citizens do feel very strongly about it. But where in the country we have millions and then only two citizens choose to stand up, that in my personal opinion, it affects the way the case itself is seen. So basically, what I'm saying is that in the law, to get an injunction against Parliament, that is a very tall order. There are decided cases in 2012, people sought to injunct Parliament on aspects of the EC and all that. It didn't work. Okay, and there are so many other cases. So to get an injunction is quite a very tall order. And in the absence of the injunction, because this agreement is meant for the public good, it means that presumably Parliament will proceed. Even though there is also one side of the law that shows that when a matter is in court, don't do anything to prejudice the outcome of the case. They say, yes, so meaning that if we're going by that interpretation, then filing a writ of summons alone is sufficient, because the other party should not do anything that will make the outcome of the case useless, so to speak. So that's how come, if you remember sometime after 2012, when some people sued that the recommendations of the Constitutional Review Commission should not be implemented. When Professor Asari sued, you see there was no injunction, but the previous administration chose to wait for the Supreme Court to decide. So, but it all depends on the person in charge.
All right. So, Mr. Pebu, as it is now, you've clearly told us how difficult it will be to seek an injunction against Parliament. So, in the case that these two citizens win this case in court, what then happens to all the processes or all the execution of the agreement?
Yes, then the court will rule that once the court says the agreement is null and void, and the ratification is so null and void, that means that the court will then make orders that the U.S. military and all those installations, be decommissioned. So meaning that they should stop the operation, cease, and then return to their home country. Yes.
Thank you very much for your time. Mr. Pebu is a lawyer sharing some legal perspective, obviously, once this has been taken to the Supreme Court, just to get some more understanding. Joy News has information all opposition political parties will be organizing a press conference on the latest development regarding this deal. We'll fill you in with all details as and when they come.